shall be commenced in Supreme Court, Albany County. Taxation and Finance, the Tax Appeals Tribunal, the Public Service Commission, the DOT, the Transportation Law or the Railroad Law or the Water Resources Board, the Comptroller or the Department of Agriculture and Markets. Let's count how many of those are that have to be commenced in Albany County. 7 things that have to be commenced in Albany County, and they are 1, the Regents of SUNY, 2, the Commissioner of Education, 3, Commissioner of Taxation and Finance, 4 is the Public Service Commission, 5 is the DOT, 6 is the Water Resources Board, 7 is the Comptroller or Department of Agriculture and Markets, and that's all of them. So like some of this stuff is just impossible to memorize. If I hear it, maybe it'll ring a bell if it's on the test. 3 just says that notwithstanding that you have to sue the Commissioner of Education, that you have to sue the Commissioner of Education in Albany County, if you're suing based upon a determination the school refused to do something for a handicapped child, which is Section 444 of the Education Law, may be commenced in the Supreme Court in the county of residence of the petitioner. And that's what that has to do with. But if they ask the question, it would be something about the education law. No, there is that exception in there that relates to, and that particular law I looked, it has to do with like determinations that they make about handicapped children regarding school. Okay. 4 says that a proceeding against the Tax Appeals Tribunal in New York City. So the New York City Tax Appeals Tribunal, you have to commence that action in the Appellate Division, First Department. 507, real property actions. That you have to commence wherever the real property itself is situated, and if it's situated in more than one county, you could do it in either one. 508. Okay, so let me actually read that out of the book so that I hear it. Real property, 507, real property actions. The place of trial of an action in which judgment demanded would affect title to, possession of, use of, or enjoyment of real property shall be in the county in which any part of the subject of the action is situated. 508, actions to recover a chattel. Action to recover a chattel may be in the county where the chattel is situated, but because it's a may, it can also be in like the county where the plaintiff resides or one of those other things. 509, venue in county designated. Notwithstanding any provision of this article, the place of trial of an action shall be in the county designated by the plaintiff unless the place of trial is changed to another county by order upon motion or by consent as provided in 511. 510, grounds. Oh shit, I kicked it. 510. So if you want to change the place of trial, the court may upon motion change it for you where 1, the county is not a proper county. 2, there is reason to believe that an impartial trial cannot be had in the proper county. Or 3, the convenience of material witnesses and the ends of justice will be promoted by the change. 511, change of place of trial. A, time for motion or demand. A demand under sub B that the county is not the proper county shall be served with the answer or before the answer is served. With the answer or before the answer is served. A motion for a change of place of trial based upon any other ground shall be made within a reasonable time after commencement of the action. B, demand for change. The defendant shall serve a written demand. The defendant shall serve a written demand that the action be tried in the county he specifies that's the proper county. Thereafter, the defendant may move to change the place of trial within 15 days after service of the demand, unless within 5 days after such service, plaintiff serves a written consent to change the place of trial, and defendant may notice the motion to be heard as if the action were pending in the county he specified, unless plaintiff within 5 days after service of the demand serves an affidavit showing that the county the defendant specified is actually not a proper county. So basically that is the 15 and 5 rule. So you make the demand, if the plaintiff doesn't answer it within 15 days, or if the plaintiff doesn't answer it within 5 days, you have like 10 more days to make your motion. C. Stay. No order to stay the proceedings shall be granted unless C. Stay of proceedings. No order to stay proceedings for the purpose of changing trial place shall be granted unless it appears from the papers that the change is sought with due diligence. So if you ask for a stay so that you could make this motion, or you're trying to change the place of trial, the court can't grant it unless there's due diligence that you're trying to change the place of trial. D. Order subsequent proceedings and appeal. Upon filing of the consent or an order changing the place of trial, the clerk shall forthwith deliver the same thing. They have to deliver everything to each other. Subsequent proceedings shall be had in the county to which the change is made as if it had been originally designated as the place of trial, except as otherwise directed. An appeal from an order changing the place of trial shall be taken in the department where the motion was heard and determined. And that has been the same since 1965. 512. Change the place of trial of action or issue triable without a jury. The place of trial may be in court's discretion in any county within the JD where the action is triable. After the trial, the decision and all of the papers shall be filed and the judgment entered in the county where the action is pending. Not sure what that is saying there exactly, but okay. 513. Misplacement of venue in consumer credit transactions. In an action arising out of a consumer credit transaction, the clerk shall not accept a summons for filing when it appears upon its face that the proper venue is a different county. B. The clerk shall indicate upon the summons a date of rejection and shall enter such date in a register maintained by him together with the name of the counties in which the summons may be properly filed. C. Notwithstanding 1 and 3 of 308, where a summons has been rejected for filing by virtue of the section, service is complete 10 days after such summons is filed in the proper county with proof of service upon defendant of the summons, together with proof of service upon defendant by registered or certified mail